West Legal Ed Center welcomes you to Your Side, Your Story, the advantage of being heard at mediation. To send a question to the presenters, type in the box below the participation tab. We also encourage all the listeners to complete a survey of this program. The link can be found under your viewer window. It is my pleasure now to introduce our speakers from National Arbitration and Mediation, Larry Schiffer and James Borkowski. Larry and Jim, happy to have you.
Well, thanks very much, Andre. We appreciate the opportunity to be here. As you just heard, we're going to talk about the advantages of being heard at mediation. This program emanates from an article that I wrote for NAM that was published in the New York Law Journal with the same title, which is part of the materials. There's also an article that Jim authored that's part of the materials as well. So please take a look at the materials. You'll find it helpful. Both Jim and I are hearing officers, mediators, arbitrators who do work with NAM, and we're excited to do this. The way we're going to do it is more of a discussion format. If you have questions, drop them as you were instructed, and we will attempt to find them and answer them. So let me just move through. There's our smiling faces for you over there, and we'll just start talking. So when I was thinking about the article that I wrote, and I was thinking about mediation, what I wanted to talk about and articulate was, what are some of the key advantages to mediation? And to me, based on a lot of experience with a lot of different types of folks who have come to mediation, what I found to be a super advantage in my mind was the ability of the parties to be heard. And it sounds simple and it sounds basic, but not everybody who comes to mediation is a sophisticated party. Many are, but a lot aren't. And to come into a mediation setting, they're not sure what to expect. They filed, perhaps they filed a lawsuit and got moved to mediation through a court system, or perhaps they decided to, in their contract, that mediation would be there to resolve their problem if a problem arose. But what do they really want? I mean, what's the key thing that they want? And to me, the key thing they want is to be heard. They want to tell their story. They want someone to listen to them and acknowledge them as people, acknowledge them as representatives of their organization that have a problem and that someone's going to listen to their problem. Jim, your experience is probably a little bit different than mine. I focus on insurance and reinsurance disputes and things like that, but I've mediated a lot of things in the court system from soup to nuts, including lots of employment cases with individuals who've never been in the court system and never been in a situation where they had to have a mediator. Do you agree with my assessment that being heard is sort of a key advantage to mediation, or do you see something else?
No, absolutely, Larry. And in my take, in my experience professionally over the last 35 years, is that I'm a trial attorney. And in fact, as I sit here, those windows behind me, I am sitting in the robing room of a judge's chambers at Westchester County Supreme Court in White Plains, New York, because we just tried a case and the jury is deliberating. So I am waiting for a jury verdict as we speak. So I'm a little bit on pins and needles. But yeah, Larry, taking it from a trial lawyer's perspective, this is one of the major advantages of mediation. In mediation, you get to pick your judge. When you're in the court system, the wheel spins, you get your assignment, you get a judge, who can be either plaintiff oriented or defense oriented, uh, who may be temperamentally suited towards wanting to settle cases. Some judges love to roll up their sleeves and try to settle cases. Some judges really don't care. I had a judge just say, one time, you guys are so far apart, there's nothing I can do here. Well, that's not what a good mediator does. So, in addition to having the flexibility and the speed where your case is not wending its way through the court system for a number of years, you get to pick your judge. And one of the key attributes for an effective neutral or a mediator or private judge is someone who has the ability to actively listen and get involved in your case. Yes.
Yeah, and that's I'm glad you brought the perspective from the trial lawyer perspective, because that's really important, and we all know, you know, going through the court system, things could get impersonal very easily, uh, depending on who the participants are. And I think what the role of the mediator is, and you said it perfectly, be an active listener. It's really the key thing, because if a party is talking in an adversarial situation to whoever is going to decide their situation, and of course in mediation, we're not deciding anything, we're helping the parties settle. But when you're in the adversary system and you're talking to a judge, or you have a jury sitting there or anything like that, are they really listening to you? Do they have any empathy for your problem, whether it's a commercial problem or a personal problem? And I think the good mediators are going to show empathy. They're going to be concerned. They're going to want to understand the party's story. And to me, that's just such a big advantage. And what it does is it gives comfort to the participants, because the participants know, okay, I've selected this person. This person, their whole job is to listen to what I have to say and to understand it, and then move on from there, and see if the matter can be resolved. And part of the reason I was thinking about this, because we all know when the dispute starts, whether there's a mediation clause or an arbitration clause, or it starts in litigation and then moves to mediation. When the dispute starts and people come to mediation, first mediation session, they already have their positions. They already have preconceived notions about the other side. And we know as mediators that interferes with sort of the free flow of information that you need in mediation. Because I think it's important to keep remembering, even though this is basic stuff, that we as mediators are not there to decide the case. We're there to assist parties to come up with a basis to resolve the case. And to do that, you need free flow of information. And that's the key thing. And when you come to the mediation, you have these two sides, and maybe they're entrenched in their positions, and they're really not going to convince the other side. And you see some of the things on the slide. These are some of the things that I find sort of interferes with the free flow of information to allow discussions. And what mediation does is it sort of opens up avenues for discussion and eliminates some of the retrenchment that you see. We've all gone through this. You litigate by email a little bit, you're yelling at each other electronically. That's not going to get you to a resolution. So for me, getting through these preconceived notions and these stuck positions is important. Jim, what are some of the things that you do to sort of get past the parties' positions and set them up for a useful mediation?
All right, one of the things that I've learned is that as far as listening skills, we attorneys, we don't have very good listening skills. I'm going to be blunt. because we are trained as litigators to be gladiators, to fight. And when many attorneys come to a mediation, they've got their briefs ready to go. They've got their arguments ready to go. They're ready to repel or rebut any argument from their opponent or their adversary. But attorneys, and not just neutrals, but attorneys would do very, very well to develop their own listening skills. Listen not just to respond and to rebut, but listen to understand. And when I say understand, I don't mean agreeing with the other side, but just listening very carefully for what they have to say. And I've found that effective negotiators, effective attorneys, that they listen and they learn, and that mediation is really a process of discovery of the other side's position.
Yeah, I think those are excellent, excellent points because uh, when the parties come to a mediation with their preconceived notions, they've already drafted papers, perhaps. Again, I get a lot of cases through the court system outside of NAM, but through the court system as a volunteer mediator, and they've already they've already lawyered up, they've already sent complaints and answers, and perhaps there's been some motion practice and maybe discovery, not in the employment cases, but in the other cases. And yeah, yeah, I mean, sure, somebody comes to a lawyer with a problem, the lawyer's going to say, yeah, I like this case. I'm going to fight tooth and nail for my client. I'm not going to give an inch. But that doesn't help at the mediation. Um, I think, Jim, you hit the nail on the head. It's important for the lawyer on the other side, and also for the party representative or the individual, to listen to what the other side has to say, because those preconceived notions of what caused this event, what was the breach, what happened here, who did what to whom, there's a reason there's a dispute here because there's another story, and it's important to understand the other story, and then you could say, okay, this is what they're saying, and maybe they're right about this little piece, but I think they're wrong about that little piece. But once you start breaking down, where things really fall out, and as you said, discover what each side has to say to them about their case and what their positioning is, you learn things. You learn, okay, so this is really what the problem is here. So now we're in mediation. Let's put our thinking caps on and figure out, what could we do about that? How could we avoid people's backs getting up? And how could we find some common ground to move forward? And, that's why, to me, mediation provides the best forum, for doing this, to air the views of each side. You have a captive audience who's going to listen to this. And the mediator's not there to return salvos. The mediator's there to say, okay, I understand. That's a very important point. And in private caucuses, then get into that stuff with a little more detail. And so, just as we've been talking, as this slide indicates, parties, what I like to do is have the parties tell their story. Sometimes it can be done in joint session, sometimes it can't, but to get understanding of the story, especially if you could say it in front of the other side, as we said before, you start gaining clarity of what the other side's position is. And so how do we keep that clarity coming, and how do we engage with the parties to really dig into the facts and the details and understand their position? So what are some of the techniques, Jim, that you use to sort of get the parties to open up and get them to really tell you what's going on?
In most mediations where there's a human client as opposed to a corporate client, I've found, and I used to be a town judge in a small town in upstate New York, but this also carries over to my work as a mediator. People have a fundamental need to be heard and to be understood. And I, it happens almost every single time that certainly once you go into a breakout room, whether it's a virtual breakout room or a physical breakout room, uh, You can have a conversation with the plaintiff or the defendant and their attorney, of course. And many times they just want to get things off their chest. They want to talk about how this case has been going through the court system for a couple of years and what the other side did or didn't do. And they want to be heard. And once they're heard, there seems to be a shift in the dynamic. All
Yep.
of a sudden, it's almost a downhill process. They've gotten it off their chest. They feel like they've had their day in court, for lack of a better term, and things becomes much easier to settle the case once they feel that they're heard and they're understood.
Right, and that was I mean, that's the essence of the premise of the article that I wrote,
Yeah,
and your materials as well. And I agree with that. Having done, I don't know how many, several dozen employment mediations for the Southern District of New York, all sorts of employment kind of craziness. Yeah, I mean, you have an individual that sues their former employer, and they sue their former employer because they felt that they were treated inappropriately, whether it was sexual discrimination, racial discrimination, age discrimination, ADA, whatever it is. There's so many avenues that people complain about, and not to poo-poo their complaint, because you have to listen and understand. These people, they're not besides the actors, they're not professional litigants typically. They're people that lost their job, many of them in a pandemic now, and had a lot of trouble finding a new position, and they felt they were treated poorly, and nobody's listening to them. Yeah,
right,
they got a lawyer, and the lawyer is nodding their head, but then the lawyer's got 16,000 other cases, and who's listening to their story? And it's just that, to me, it's the greatest and most important thing in the mediation, to let, particularly where there's an individual, but even in the corporate setting, to let the party tell their story and not hide behind the lawyer. Sometimes you have to deal with that, and sometimes it doesn't happen in the joint session, and sometimes it has to happen in the private caucus for all sorts of reasons. But if you have a serious sexual discrimination action where there was physical touching alleged, the open session might not be the best place for that, depending on who the party is. But in a corporate session, there's no reason why the parties can't talk to each other. But it's good, because once that individual, even if they're a representative, starts talking and said, "Listen, this is what happened. We had this. We tried to do this. They wouldn't do it. We feel bad about this, but we're entitled. Blah blah blah." They start, as you said, they get it off their chest. They feel like they're getting their day in court, and they get some relief. When I talk to these parties, I explain to them in the session, look, you're if it's a Southern District case, you're in court. Everything's backed up because of COVID. You know, things are picking up, but there's a lot of cases out there. You may wait a year or two or three before this case goes to trial if you're going to go in that direction. And we have an opportunity today for you to tell us what the problem is, and let's work through it and see if we can come to a resolution so you could put this behind you. To me, a lot of what needs to happen is people have to move on, and they have trouble moving on. And what we do as mediators is help them move on, and explain to them, yes, this was a terrible thing. This was the most important thing that happened to you at this period of time. But you've moved on, and now your emotions have to move on, and you have to let it go. You have to let it go the right way. You have to let it go being satisfied that you're letting it go, not being forced to let it go, because we don't force people to settle. They have to want to settle. But when they tell that story and get it out, that helps them move on a little bit, and that's sort of an important thing.
Yeah, one of the techniques which I've learned over the years, and it's in this book, which I'm going to be discussing in a little bit. It goes by various names, but the name you hear most frequently is looping. It's basically when you're having a conversation with somebody, let's say in an employment case where a female feels that she's been wrongfully discharged or didn't get the promotion, uh, and wants to tell her story. And you let the person speak, let her get everything out, and to let that person know that they're being heard, you sort of repeat back what
Yeah,
they've told you, and you say, well, Larry, it sounds like you're telling me that you feel disrespected and you got passed over for that job because of your age or your race or your sexual orientation, and that must be a horrible position to be in. Do I have it right? And then a lot of times the answer is just, yes, that's right.
but he
And
got it.
therefore, exactly, exactly. So, looping I found is a very effective way of communicating and connecting with the litigant.
Yeah, I mean that's just a fantastic suggestion. And yeah, it's nice to know the technical name for the technique. I think we all try to do something like that, but having it in mind and thinking about it proactively, I think is
Right.
you know,
It's one thing to say, yes, I understand, I get it. But when you repeat back and they hear that you understand what they're saying,
yeah,
that connection is established.
yeah. That repeating back or the looping is just an excellent suggestion to folks that are interested in being mediators or doing it. So let's move forward to the mediation statement. Uh, I mean, in every mediation I'm familiar with, there's a mediation statement filed by each side. In the court systems, it's not shared. In some private mediations, the mediation statement may be shared, depending on the rules or depending on the agreement of the parties. Most of my experience is it's a mediation statement for the mediator, not for the other side. Uh,
Right.
yeah, but it can go either way, and so I mean I've set out some things on this slide, but I mean I think what I like to ask, what I do is when I'm assigned to mediation, I have a an initial conference, and the point of the initial conference is not just to set the mediation date, but also to sort of get the lay of the land a little bit and talk about the mediation statement for a second. And what I tell the lawyers, because this I'm talking to the lawyers at this point, what I tell the lawyers is, look, this is a mediation statement for me. It's your opportunity to sort of lay out, what your side's position is, but you got to do more than that. You got to tell me, what have you had some negotiations? Where do they stand? What kind of outcome are you looking for? Are there any creative ideas that might exist beyond dollars that could resolve a case? I mean, that doesn't happen a lot. um, Particularly in the employment disputes, because you're never going to have a rehire on those kinds of things for the most part. But I've had multiple mediations where the resolution was something other than dollars. I'll just give one example, and it's a little off topic, but it's something that could be put into a mediation statement by an advocate saying, in addition to dollars or separate from dollars, my client would like the following relief. And you might be creative in that relief. So I had a mediation some time ago with a professional boxer who was suing one of the sanctioning organizations that puts on boxing matches and gives out belts. And this guy was a world champion in that organization, uh, and they stripped him of his belt because he didn't fight when they told him to fight, whatever. And we ended up resolving the case because the lawyers were very helpful and creative, uh, and the resolution was we found a way through their rules and regulations to reinstate the boxer, the plaintiff, in a particular category that would allow him to have a fight, and if he won that fight, then fight again for the championship. And it was a marvelous creative solution, and I don't take credit for it. One of the lawyers sort of came up with this arcane rule that allowed them to do that. But when we started the mediation, it was all about money. And the plaintiff's manager, who was also his wife, was, I want millions of dollars. I want millions of dollars. I want millions of dollars. And I literally looked at the boxer and not his wife and said, "You tell me what you want to do. You haven't fought in 2 years now, and you're not getting any younger. Do you want to fight, or do you want $1 million maybe 3 years down the road? Which one do you want?" And that got through, and he obviously wanted to fight, and we were able to resolve it. So it's important in the mediation statement to think about, are there alternatives? Is there something else you can do um, other than dollars, which gets very impersonal, and that's a
Well,
whole other
that's one of the
story.
huge
Yeah.
advantages, Larry, of mediating cases is that when you go to trial, you are placing your client's fate in the hands of six strangers. Uh, and I've won cases that I should have lost. I've lost cases that I should have won. We're going to be getting a verdict very shortly in a case. I don't know what the heck's going to happen. And that's just the point, that litigation is about risk, and it's ultimately sometimes it boils down to a crapshoot. And with mediation, the parties get to control the outcome. It's
Yep.
not six strangers. You can negotiate whether it's dollars or whether it's a more creative settlement, like you were talking about. You can't do that in court, and that's one of the big advantages of mediation.
I mean, I think that's just an excellent point, and fits beautifully with what we're talking about. You know, and it starts with representation. So it's the lawyers who represent clients in mediation need to think about exactly what you just said. That okay, we now have an opportunity to chart our own course, and how are we going to start this? How are we going to present this? Who's going to do the presentation? At what point do I let my party speak? And how can I help the mediator move in a direction that crafts a resolution that everybody is going to be at least reasonably happy with and willing to walk away from a potential lawsuit or something worse. Now, again, you may have an agreement that requires mediation, and that's the end game, and there is no court situation. But a lot of these mediations come out of court situations, one way or another, and this gives the lawyers an opportunity to say, okay, my point is not to advocate here to win. My point is to advocate to find a resolution that we can craft together that makes everybody as happy as we can make them, but resolves the case. And that, again, it starts with the representation. And so to me, when I hold the joint session, I like to have, I give the lawyers an opportunity to do an opening statement, but we talk in advance about that, and we say, look, you're not in court. I'm not the judge. There's no jury. The point of this is for you to impart information to the other side, as well as educate me to give us an idea of what's going on here. So I think it's important, for counsel to start the process. But I find, as we were talking before, the day in court concept, I find it's equally important to have the party, after the lawyer's done, chime in and say what they want to say, particularly in front of the other side. Now, like I said before, it doesn't happen all the time. Sometimes, because of the nature of the allegations or the makeup of the party, they just don't want the party to talk at that time. And sometimes they don't even want to be there at a joint session. They don't even want to do a joint session. I've had several mediations where we started in private caucuses. I don't like that, but it's a party's process, and I don't want to make somebody uncomfortable. So we're going to make them comfortable because we're listening to what they have to say, and we're going to do it that way. But how do you feel about the lawyer speaking, the client speaking? Do you have any particular order or practice that you use?
Well, in the general conference room, before we go into breakout rooms, uh, I like to hear opening statements. Some attorneys never do them. They just say,
Yeah,
you know what, we've had motion practice, we've had depositions, we both know what our positions are. But I think that it's good that each side learns the other side's arguments, because many
yeah,
times during mediations, one side will learn that there's something about the case that the other side thinks is a big deal, that they really discount it, or the other way around. So, you know, having said opening statements, I mean, a couple of minutes. I'm not talking about,
yeah.
giving a war and peace, but something where each side establishes, the strengths of their cases, and we can talk about the weaknesses of their cases privately in the breakout rooms. But I really encourage, and I think we'll talk about this, pre-mediation submissions, which I think are key, but I also encourage opening statements.
Yeah, no, absolutely. Actually, we could step back for a second. What do you like to see in a mediation statement?
Well, my background, the cases I handle general liability, uh, construction cases. In New York State, it's called labor law 240 cases, where a worker is injured on a construction site. I also handle automobile accidents and premises liability. So, as far as those type cases, uh, first, let me tell you what I do not want to see, where basically it becomes a dump of the file. The attorney has a paralegal copy all the deposition transcripts, all of the medical records, all of the physical therapy, and I've got 500 pages. I don't need that. For me, a mediation submission is something that allows me to get up to speed, to identify the issues, and be more effective when we start the mediation, because it's not cheap mediating all the time. So you want to give value and you want to be effective for what you're being paid for. So I want to see some of the pleadings, maybe a 2 or 3 page synopsis of the case. If there are photographs which the party believes are important in the case, and medical records, just snippets here and there, the operative report. I don't want to see 200 pages of physical therapy notes. I get that, but just a short, tight pre-mediation submission that's a couple of pages with the attachments that they think are important.
Yeah, no, that sounds like a great outline. So from my perspective, my mediations and arbitrations are in two different contexts. One context is the court annexed mediations from the Southern District and New York Commercial Division, and those can range from any kind of dispute that exists in the courts, but Southern District, you get a lot of employment cases.
Mhm.
And again, we're not arbitrators, we're not judges, we're not deciding the case, so we really don't need the whole file. We need what you said, a brief outline and a bit of a roadmap of really what's the essential issue. The pleadings, I typically download myself or have them send it to me because I want to see what the complaint and answer is. The answer is usually not very helpful, of course, and sometimes the complaint isn't that helpful either. But at least you know what the allegations are. And I say the same thing as you. I say if there's a particular document or other piece of evidence that you think is highly relevant to helping resolve the dispute, send that along to me so I have that. So yeah, I mean, I've done some personal injury stuff, but I don't need the medical records easy either. Uh, but on the commercial side, what I get involved in are insurance and reinsurance disputes. And in that context, really what I need is the contract. I need to understand what the contract is. I need to see the contract. I need to understand, why they're saying there's a breach of this contract. What are the essential documents that formulate that brief? We all know in litigating cases that, we're going to produce thousands, if not hundreds of thousands of pieces of paper. And we also all know that there's only going to be maybe 10 pieces of paper that are relevant. You could have the biggest case in the world, and there's really going to only be 10 or 20 pieces of paper that anybody really cares about. All that stuff the 75 exhibits you did with the witnesses and depositions are nice, but what are you going to really use at trial? What does a trier of fact really need? It's just the essence, and the essence is going to be a handful of documents, not going to be everything. So I agree with you. I try to encourage them to keep it simple and to not go crazy. I just want to touch a minute on private caucuses or breakouts. Those to me are absolutely critical. I mean, we start the process in the opening session. The parties start telling their story. It's important for the other side to hear the story because they may learn something that they're not familiar with and find an emphasis that they weren't focusing on. But in the private caucus, that's where we really dig in. That's where it's important that the party, whether they're a corporate representative or an individual, really, okay, you started the process and you told us in the opening statement what's going on, but tell me again. Tell me about what really happened when you worked at this company, or tell me how this contract got started, and how did this all get broken down? I mean, it sounded like you had an ideal position, and then all this stuff happened. Tell me about this stuff. Who did it? How did it happen? How did you react to it? And tell me how you're feeling now, and how can we move forward? And that's what the private caucus is for. And I tell, whether it's live or in person or virtual, when I go, typically I go to the plaintiff first, but not always. When we break from the opening session, I say to the other side, listen, I'm going to be there for a while. Go get lunch, go do something useful. Keep the screen on because I'm going to come back, or keep don't leave the room because I'm going to come back. But yeah, it's going to take me a minute because it's important to really in the caucus, and particularly the first one, is to get the dirt, to really dig in, to get the story, and really let the party emote and get everything out, and make sure, as you said, you loop back, you reflect it, you show empathy, and you mean it, and you get the better understanding of what their problem is. Why don't you touch on
Yeah,
a private caucus for a minute,
yeah,
or
Larry.
anything else?
I I handle things a little bit differently than a lot of other mediators. Um, I am a firm believer that the parties have chosen their neutral. They've chosen their mediator, someone that they think has the skill set. Many times, you have repeat customers coming back, so or you've known them from trying cases in court, and that's a compliment. They want to mediate with you. So I'm a big believer that trust is the secret sauce of mediating cases. And what do I mean by that? Um, in the first round of caucus rooms, what I typically try to do is, after hearing out the other side, I have a very frank conversation. It's almost like, Catholics being in confession. I want them to confide in me. And I will say something to the effect of, listen, okay, I'm not going to ask you what your bottom line is, or what your walkaway number is, or for a defendant, what your authority is. But in the strictest of confidence, and I mean that, can you give me some idea of the neighborhood of where you're looking to be? What makes sense for you to settle this case? Or depending on what the subject matter of the case is,
Right.
what makes sense for a resolution here? And I've got to tell you, Larry, 90% of the time, some attorneys kind of play games and they're still playing poker with me, but 90% of the time, people are frank and they say, okay,
Yeah.
this is where I need to be. And then once I've had that conversation, say with the plaintiff, I go in the break with the defendant and I have the inverse conversation. And hopefully, after the first round of caucusing with both the plaintiff and the defendant, at least we're in the same universe, hopefully,
Yeah.
and I can work from there.
No, I think that's a great way to do it. I think everybody plays it by ear. You have to see who the parties are, what the dispute is about, to decide how quickly you're going to get the dollars. But it's important to understand what the playing field is. We've all had these cases where the defendant is at nuisance value and the plaintiff is in the millions. And so how do you close nuisance value in millions? And it looks daunting in the beginning, but our job is not to give up. Our job is to find a way to close that gap if possible. And by allowing them to tell their story, by allowing them to gain your trust and trust you that you're not going to say anything to the other side that you shouldn't say, because we all repeat that multiple times. I'm not going to tell them anything unless you authorize me to tell them. That helps gain trust. One of the other things that I do in the court mediation sessions in particular, because I do those as pro bono, I tell them that. I say, I'm a volunteer mediator, and while I'm helping you resolve your case here, I'm not working for my clients. So I take this very seriously, and I want to hear everything you have to say, and I'm going to do whatever I can to help you try to resolve this problem so this case doesn't have to continue. And in fact, I'm not going to take a break. I'm not going to eat. I'm not going to do anything other than talk to both sides here, and until we have a resolution or it's obvious we're not going to get anywhere. But I'm not going to give up. So I want you to know that this is very serious for me. And when you tell people that, most, as you said, most become frank, most become helpful, and they take it seriously. Obviously, we've all had a few jokers. There's nothing you can do about that. But for the most part, counsel and parties take these things extremely seriously. So I want to, let's see how we're doing, 20 minutes. Okay. I want to talk about a little bit about the commercial side a little bit. Who's representing who. So in the insurance and reinsurance disputes that I get involved in outside of the court system stuff, it's typically business representatives, obviously, because these are companies. These are large companies with big legal departments, and sometimes you'll have a risk manager for a policyholder if it's a dispute involving a policyholder. Sometimes you'll have a claims adjuster if it's a claims dispute, and you have these in your disputes as well. And in the reinsurance disputes that I do, it's either going to be somebody from the legal department or somebody from the claims department. Often it's a lawyer who I know actually, and you're going to have all these people, corporate representatives. And so what does a corporate representative care about the case? Well, they all care about the case because we know as litigators that when we're representing the client, we say to them, particularly in deposition preparation, they're calling you a liar. You can take this personally. You should take it personally. They're calling you a liar. They're saying you lied to them about this contract. And so from the mediation standpoint, when you're in there, you have to be prepared that the corporate representative is going to act just like an individual client, and because it's their budget or it's their line item or something like that, or they're the one who wrote the contract, and so they're going to take it personally, and you have to give them a chance to articulate just like you would an individual client, because they're going to have a lot to say, and especially if it's the kind of case where one side is really accusing the other side of malfeasance, that person's going to take that personally if they're the corporate representative who's sitting in the room. So to me, the corporate representative is a key player in this dispute, and they have to vent and express their views just as much as an individual. Have you found the same thing?
Yeah, absolutely. And it's also really important, and you'd be surprised how frequently this happens, is that the decision makers need to be available. Say in an insurance case, you've got to have not just the claims rep, but many times the supervisor if the claims rep needs additional authority, considering, time zone variations, what have you.
Yeah.
I've had so many times where it's frustrating, where we just need a little bit more authority to settle a case, but the next person up in the food chain, the chain of command, is not available. So it's key that they not only be heard, but the ultimate decision maker be available.
Yeah, that's always a real tough one. I mean, we all have those. I mean, I get them a lot in the employment cases when there's insurance behind the employer, and obviously insurance and reinsurance disputes. But in all sorts of corporate disputes, you know, you might have the risk manager, but the risk manager might not have authority. They may have to go to the CFO or somebody like that. And so, you know, I mean, going back to the initial conference that we have with the parties, when we talk about the mediation session, you know, we make it clear, look, there's got to be a party showing up, but there's got to be a decision maker either showing up or available, because we can't resolve this if, you know, you have to go back and talk to somebody 6 months later. That's not the way it works. You know, be you know, you may think it's nuisance value, but have somebody available, because you never know what happens, and we're going to try to settle this thing. So that's absolutely critical. Um, okay, so let me read the code the program code that you need at this time. We're well into the session. So in order to comply with New York regulations, attorneys looking for CLE credit in New York will need to be able to provide a code when they fill out their forms. This code is not intended for the West Legal Ed Center audience, either live or on demand. I will read the code twice and only twice. I will not repeat it or email it. So please make a note of it if you're in New York and you need the code. So the New York code, program code, is 5, B as in boy. Not a 5 or an S. Jesus, it's terrible.
I
That's
think
a
it's a
5.
five.
Yes, 5, B as in boy, 3337 dash 40423. All right, I will read that one more time. Sorry, I tripped over it in the beginning. One more time for the code. This is the code you need for New York regulations. The program code is 5, B as in boy, 3337 dash 40423. Okay, housekeeping done. So we talked a lot about the opening session, and encouraging parties to summarize their position and doing all that. And Jim, is there anything else you want to say about the opening session?
No, I think we covered that. I mean, I encourage, a brief opening statement from both sides and then go into the breakout rooms.
Okay, so yeah, we sort of foreshadowed. Oops, we sort of
By the way, could
foreshadowed
I
this.
jump in with my plug of that book?
Oh
I'm
yeah,
an
yeah, go ahead.
I'm a non-paid spokesman, but I wrote an article in the New York Law Journal about a book called "Never Split the Difference." Never split the difference. I think the second title is "Negotiating as if your life depended on it," and the author is his name is Chris Voss, Voss. Chris Voss was the former chief hostage negotiator for the FBI.
Wow.
And he changed the entire mindset of how the FBI negotiates with hostages. It's a great read. He tells great war stories, as you can imagine, where he was in life or death situations with terrorists and drug kingpins and bank robbers and what have you. Um, the old mindset going into the 80s for the FBI was just to keep the hostage taker talk, 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 wait for the opportunity to present itself and go in and shoot. Just kick the door in and end it. Chris Voss changed that approach totally, and that's why this is applicable to mediations and negotiations. He is a big believer and a big proponent, and changed the way the FBI does it in using what he calls tactical empathy. Tactical empathy, and what is that? That part of it is looping, but it is not just talking to a hostage taker or your adversary for that matter during a mediation, but listening very carefully, not just hearing them, but listening to understand. And as I said earlier, and I learned this from Chris Voss, is that mediations or negotiations are a process of discovering, for instance, what is the other side looking for? What do they need to settle the case? Maybe besides dollars, like you mentioned before, Larry, there are other things that they're looking for that might make it easier to settle a case. And again, please read the book. It's absolutely extraordinary as far as, for instance, how to say no in an elegant way and not in an adversarial way. And what he always does is he tries to sort of turn it around with a question where, say, Larry is the defense counsel and he offers $350,000 on an automobile case. Instead of saying, Larry, you're not even close, no. It's more like, well, I've got these great injuries. How can I recommend that to my client? So you've said no, but you haven't said no, and you keep the conversation going because no frequently can shut down a negotiation. So just the techniques that he learned and he now consults in the private sector. He has a company called the Black Swan Group. They teach negotiation to Fortune 500 companies and he holds seminars. They it's a fascinating read. It'll change the way that you negotiate. It changes the way I mediate.
That's great. Well, thank you for that recommendation. Hopefully, if people are interested, they'll go seek that out from Mr. Voss. Just checking, there's no questions, but very good. Okay, so we've talked about the opening session. We've also, I mean, this summarizes the day in court concept that we were talking about on this slide. You know, to me, the first private caucus is the real opportunity to let the party really fulsomely have the cathartic benefit of getting everything off their chest and really laying it out. Because yeah, in the opening session, the other party, they're really not going to give you the nitty gritty. They're just going to give you the essence. But in the first private caucus, that's where you need to pull it out of them and really identify what the issues are, listen intently, as you said before, listen with purpose. You know, I try not to interrupt their narrative. I let them go, which is why the first session is often pretty long. I mean, it could be a half hour, it could be 45 minutes even. It's important to let them go and really get everything off their chest and understand their perspective and ask clarifying questions and do the looping that Jim said, which is really important. You know, to me, getting all this out in the opening caucus and really finding out what's going on, including, you know, where do you stand and, you know, how are we going to find a resolution forward? What are your thoughts on that? And, you know, what can we do here? That really sets the stage for positive negotiation. I think I mentioned before, we've all been in these cases where the playing field is astronomical, but after the first caucus, all of a sudden, things start converging. And maybe, you know, maybe you make it happen, maybe you don't, but there's a good opportunity to use that opening session as a way to get things way to get things going. One of the things I try to avoid in the first session is really going right to the offer counter offer part of this thing, because to me, and I mean, this is more for the individual parties as opposed to the corporate representatives, but to me, you know, jumping right to dollars sort of demeans the individual, demeans the process, and makes it very clinical. And you know, I try to avoid that out of the gate. I really want to hear their story and let them tell their story, not, you know, say in the first minute, you know, well, you know, where do you stand? You know, how much do you need to get rid of this thing? Because then they feel they're not being heard. They think that, you know, you're only there trying to negotiate dollars and you really don't care about what their situation is. And so, you know, I like to really not get into the offer counter offer part until after they've had that opportunity to have their position heard. What do you think about that, Jim?
Yeah, I totally agree. I mean, it's not just dollars and cents. Like I said earlier, it's a question of the parties feel like they're being heard, and that there might be other considerations on the table that they want. And it's another advantage of mediation as far as how you have control over the outcome of your case that you wouldn't have if you were to try a case in court. For instance, non-disparagement with an employment case, Larry. I'm sure you know that sometimes it's very important that the parties negotiate a non-disparagement clause or a
Right.
confidentiality clause. You know, these are the sort of intangibles that come into play that you can fashion a settlement with.
Yeah, no, absolutely, absolutely. Um, so, why allowing the party to tell their story is important, also affects commercial disputes. So I'll use an example, from my world, insurance and reinsurance disputes. I know for a fact that the party representative wants to feel assured that somebody is listening to the facts and the law and the arguments and understands what the dispute is about. Uh, these people negotiate settlements for a living. I mean, that's literally what they do for a living. And, if they feel that the mediator doesn't have a clue, doesn't understand the business, doesn't understand what the legal issues associated with that particular dispute, they're gonna back off from any feeling that let's try to settle this thing. I mean, maybe you get it done anyway, but you really have to listen. You really have to demonstrate that you understand their position. You understand, the legal arguments. You understand the technical arguments that involve, whatever industry it happens to be. So they feel uh, that that you know, somebody appreciates the issues, and they have trust. They have some trust that, okay, I have somebody here I could deal with. So, I mean, that's really why, particularly in a commercial dispute, it's really important, particularly with, claims examiners and adjusters and people like that. I mean, if they think you don't know anything about their world, they're just not going to trust you. And as you said before, Jim, trust is key. Do you have some comments on this topic?
Yeah, I have a couple of sort of last minute thoughts that little surprises that can throw a monkey wrench into what is about to be a settlement, which are very frustrating. I mean, the importance of being prepared is paramount, that the attorneys know their file. If there are any last minute issues that might pop up, say in the personal injury world, where there might be funding loans for a settlement, there might be Medicaid or Medicare
Yeah,
liens on a
yeah.
settlement, and all of a sudden you think you have the case closed, and oh, gee, there's this funding loan out there that was initially $40,000 that's now $100,000. So, okay, so I got a verdict, so I'm going to have to leave in a couple of minutes.
All right, we're
So,
almost done.
yes, yes, the judge just popped in. Yeah, those last minute surprises like loans or subject to the client's approval. I hate that one because a lot of times they come back and they need just a little bit more. And one thing that I always try to do with a case, if it doesn't settle, and we do settle the vast majority of our cases, but if a case doesn't settle, I always give the parties my cell phone number, my personal cell phone number. And I'll say something like, listen, in reality, we're not that far apart, notwithstanding everybody's posturing and their positions. We're not that far apart. But here's my cell phone number. Please give me a call. And I settle a significant amount of cases after the fact.
Yeah.
When one side realizes there was money on the table and that there's not going to be any more, and they think about what's another year of litigation going to be like, they call and we settle the case.
And just to follow up on that, because I just had one for the commercial division where, we closed the playing field to here, but we couldn't get it closed.
Uh-huh.
And I constantly followed up, followed up, followed up, followed up. And just a few days ago, they sent an email in after my 15th follow up saying, we've come to an agreement.
Yep.
And so by the mediator saying, "Hey, I think there's still more to talk about," sometimes the parties just get it done on their own, particularly if the gap is a smaller gap that could be bridged by themselves. So just quickly, obviously there's more than one private caucus, and the purpose of the subsequent caucuses are really to dig in and find a resolution. And a lot of times it's just talking about dollars, but sometimes there are facts that come out that need to be told to the other side. And again, you have to ask the party if you can say it or not say it. And it just constant listening, because you never know. All of a sudden, you hear a party say, "Well, I also feel this way," and maybe that's something new, and then you have to explore that. So, the active listening that you mentioned, Jim, is absolutely critical. And the subsequent caucuses are opportunities to dig in even deeper and find a pathway towards settlement. Uh, Anything further that you'd like to add?
I think we've covered the bases. I hope we have.
Yeah, no, I think so. I mean, I appreciate you're getting involved in this, and I want to thank Sharon Peterson at the NAM for recommending you to work with me on this. I mean, it was a great experience for me, and I've learned things, and I may have to go get that book from Mr. Voss as well.
Definitely.
That's really cool. I do not think we have any questions in the question area, and we're just at 60 minutes. So thank you all very much for listening to us this morning or this afternoon, depending on where you are in the world. Maybe even this evening, although I doubt it. In any event, we appreciated the opportunity. I hope it was useful for everyone. And on behalf of NAM, we thank you. And if you need mediators, contact NAM. Jim and I are on the New York listing, and there's lots of other folks like us that would be happy to help you resolve your disputes. So thank you very much.
Thank you all. Take care.